Okay, thank you, everybody. Welcome to Zoom across the Atlantic. We're actually zooming across more than just the Atlantic. We have one of our panelists, Nigel Lithman, is in Israel. So I think we're covering about a dozen time zones here. I want to thank you all for coming today and participating. And the point of having this get together is to establish that most of what we know about each other's legal systems is probably not true, and we have a lot that we can learn from each other. And start off with one of the biggest differences that we have in our systems is jury selection. And I'll start off by asking Judge Patrick, how do you pick a jury in your court in England and Wales? You're in Bristol, right? The High Court in Bristol?
The Crown Court in Bristol. Can you hear me all right?
I can hear you, yep.
Good. So far as jury selection is concerned, we work out how many trials we're likely to have in a particular week, and we put in a bid for jurors to a central summoning bureau. And anybody who is on the electoral roll, anyone who's able to take part in any elections, is then liable to be summoned for jury service.
So it's registered voters.
I'm sorry?
Registered voters.
Any registered voter is eligible. It used to be that quite a lot of people were able to be excluded to get themselves knocked off the list, but it's become more recently much more difficult for that.
It's in Florida, it's driver's licenses. If you have a driver's license, you can be on the jury.
I'm with you. And so your jurors are selected, and they come to court. They arrive at about 9 o'clock, and then if we need a trial, there's a ballot. Those who are summoned to come to the court, if they've got a good reason not to serve because of booked holidays or hospital appointments, something like that, they might be weeded out before they get to court. If we know we've got a case that's going to last longer than a couple of weeks, then we'll get more jurors in. And then we have a ballot, and it's a random ballot. We generally have a ballot of about 16 for a fairly standard case. 16 jurors are brought up to court, then they're balloted again. And the only reason that they can be excluded from service on a particular jury is if there's a cause to keep them off, if they know somebody in the case, if they're affected by the case particularly closely.
So there's no peremptory challenges in your court?
Not anymore. Peremptory challenges have gone. Technically, the prosecution are still entitled to ask. The old phrase is the Crown asks a juror to stand by, and that means they then go to the bottom of the list. It's not that they're knocked off the list, but they would go to the bottom of the list. But if there's a good reason, if they know a defendant, if they know a witness, if they live in the immediate locality, if they're connected, if they've been affected by loss of a business, that sort of thing, then they can be objected to. So otherwise, they're then balloted and then called very quickly. And as we had an earlier discussion, and I was telling you of the time I remember when O.J. Simpson was being tried in the States, and there was very extensive legal selection, jury selection going on. And at the same time, in the United Kingdom, a very notorious woman was being tried for murder. She and her husband had killed, I forget how many, 7, 8, 9, including members of their own families, and had buried them under in the cellar, which had a huge amount of publicity. And when it came to her selection, the jury selection for her trial, it took 12 minutes from ballot to swearing the jury in. The judge inquired whether everybody had heard about it, and so inquired whether anyone was particularly connected to the trial. They said no, and 12 minutes later, they had been impaneled and sworn.
So is it just a matter you press a button and you pick the jurors when it gets to the?
It's exactly that. We've got a jury office. They come in, we tell them we need a jury, and they press a button. They produce the names of 16 people,
right?
And then they file up to court.
Who gets to press the button?
That'll be it's somebody in the jury summoning office. So we've got a central place where they all go, a big lounge where they all go.
Okay.
And so we ring down, say we need a jury, and then they press the button and it prints out the names for us.
Okay, all right. Judge Scriven, how does that compare with how juries are selected in the federal system? You have to unmute yourself, Judge Scriven.
It's very different. We have the initial process. We either, some districts use the electoral rolls as the basis, and some have expanded to driver's licenses. And with the driver's license, we get a broader cross-section of the community, as you might imagine. Not as different as it used to be before the election of President Obama some years ago expanded our pools such that they are somewhat more identical. Once we pick the people who are in the panel, then the judges are all asked, how many jurors do you need for a trial? And our jury services people will then select randomly through a computer system the venire for that judge. And it could be 35, 45. I don't know if you are following the Ahmaud Arbery trial, the federal hate crime trial, but they summons 1,000 jurors as part of that panel. And then there was a week of jury selection just with the lawyers whittling that group down to a smaller venire. And then that venire was brought into court, and that venire answered questions about their views about race and their views about the case, their knowledge about the case. And from that group, it was winnowed down to the jurors who actually served. And I don't know how many were seated, but I would typically seat 14 jurors for a 2-week trial, giving 2 alternates such that if we would lose a juror, we would be able to fill it in. I don't allow lawyers to ask questions during jury selection unless they are follow-up questions. Some of my colleagues do. I ask all the questions that are pre-submitted by the lawyers as voir dire. So if there might be a case involving, say, theft of trade secrets, I might ask in a civil case, I might ask the parties to send questions, and they might send questions like, are you an inventor? Do you have your own business? Have you ever sued anyone? Have you ever been sued? And from that group of people, the lawyers would consider their cause challenges, and they would all have their peremptories, which is 3 per side in a civil case. For any reason, I don't like the color of your tie, I don't like the way you looked at me, they would be able to exercise their peremptory. And ultimately, we would get down to the 6 to 8 to 12 to 14 people who would sit on a typical jury.
And the size of a federal jury is what?
It's 12 for a criminal trial and 6 for a civil trial.
Judge Patrick, what's the size of the jury in your country?
It's 12. Well, in England and Wales, it's 12. In Scotland, it's 15, I think.
Okay. All right.
For criminal and civil?
I think, I'm not sure about civil. I'd need to look that up. I think it's 12 in civil.
Let me ask Judge Hammond, size of the jury in Britain. You have to unmute yourself, Judge Hammond. Yeah, we can't hear you. We'll get back to you, Judge Hammond. Okay.
Can you hear me now?
I can hear you now. The jury size.
In civil cases, it's 6.
Okay, and 12 in criminal cases.
It's 12 in crime and 16 in Scotland.
Okay. Judge Colbert, how does that compare in Louisiana? What's the process of jury selection?
We basically follow the same system as the federal court. As Judge Scriven said, what I didn't hear anybody say is the issue or the phenomenon we have here of backstrikes for jurors once they are actually seated. It's mostly up to the individual judges here whether they want to let a attorney backstrike a juror. And what I mean by that is, again, it's the same system. We let our clerk of court know ahead of time, at least 2 weeks, that we will be having a jury trial. We may have a jury trial. Our calendar is set at the beginning of each year, and we go ahead and that panel is sent out to the attorneys who can submit written questions to the judges, which will be given to the clerk, who may send them out, or when the jurors get here that morning, they are given the questionnaire and they answer the questionnaire and give it back to the actual attorneys, depending on the case. We have some difference. Depending on the crime, we have either what we call a 6-pack or a 12-pack, which means 12 jurors or 6 jurors. The 12 jurors, of course, for the more serious crimes, I think anything involving only a hard labor sentence. The 6-pack for those with or without probation or parole, where the person can be given a suspended sentence. But that's what we typically do. But again, the only thing I haven't heard from either Judge Scrivel or from Judge Patrick is whether they allow back strikes. And again, what I mean by that is once the jurors are seated, say if we need a 12 panel, and again, I tend to do 14 as she does, 2 alternates, are the attorneys allowed to go back and say, well, I chose this person from the first panel we had. I don't like this person. I'd like to strike this person now and continue questioning the potential jurors to get somebody to take his place. But that's each judge makes that decision depending on the case, whether they're going to allow that or not.
In Florida, there's been a constitutional challenge to disallowing back strikes, and they are constitutionally required. And so even though I am a federal court and I don't know that I'm bound by that, in order to avoid any appeals, I allow back striking, but not after the jury is seated. During the course of jury selection, you might have 40 people being considered, and you go through those 40 people, and then you get to a number where you're almost close. And then the lawyer says, you know what, I passed on juror number 9. I want to go back and strike juror number 9. And that's what I consider to be back striking. And I allow them to go back, even though they're already at juror number 40. And now they're looking that jury number 9 is actually going to get on the jury. They'll go back and strike 9. And that doesn't bother me. As long as they don't touch my jury after I have said, this is the jury, everyone's sworn, they can do whatever they want to do.
Judge Lithman, which would you rather do, the American way or the British way? I don't know if we can hear you. We're waiting. Can you hear me?
I didn't hear who the question was directed to.
That was, it was directed to Judge Lithman, but I don't think he can hear me. Let me ask. Go ahead, Judge Lithman. I can't hear you. Okay, let me ask Judge Hammond. Is there a historical precedence for being able to ask prospective jurors questions?
I can't answer that one. We never do.
So
It's never happened to me in my lifetime. And it was a long lifetime at the bar. No one ever asked a juror any questions in my court.
We would, if in a high profile case, in fact, in most cases, particularly in Crown Courts in small centres where there's a good chance that defendants and witnesses will know each other, the lawyers and the judge will agree a list of questions for the jury. Do you recognise anybody? Do you recognise the names of these people? Are you closely associated with this business? And so, well, a set of names and locations would be drafted in advance, but it's all pretty uncontroversial. It's people who are going to, whose names are going to crop up in the course of the trial, and so it's fairly easy to come up with a list. But in terms of lawyers asking direct questions, that would never happen.
Yes, Mr. Feudeman, although he speaks with an English accent, he belongs to us. He came here when he was 17, and you guys can't have him back. So let me ask, and he spent time watching court proceedings in Britain. I think your father was a solicitor, so let me put you on the spot. You okay with asking prospective jurors questions, or would you rather do it the English way?
He pretends to have an English accent. I'm not buying it, but go ahead, Feudeman.
Well, I'm open to cross-examination if anyone wants to question my origin, so I'm welcome to open up. But as a defense attorney, I much prefer seeing the American system, of course. In Florida and state court, I can spend a whole day in certain cases. And I think you get to know your jury, you get to ask questions that you plan, you get to find out a lot about jurors, you interact with the jurors, sometimes you build a bond with the jurors, you can really learn a lot. I think a lot of lawyers make a big mistake in state court. They spend so much time on the trial and not enough time on the jury selection. And especially here in Pinellas County, the judges are very, very relaxed in allowing as much time as you need. Generally, in a murder case, we may spend a whole day to 2 days picking a jury. And so as a defense lawyer, it is invaluable. We get strikes, either 6 or 10, depending on the case. And by far and away, I am glad as a defense lawyer that we stay with the state system. The concept or the thought process of booking a high profile case in 12 minutes is a little frightening to me. And so I much prefer the system here in Florida. It seems a little fairer, and quite frankly, and you can weed out some issues. Of course, you never know what you're really getting, but I am very, very glad that we have the system that we have in play as a practicing defense attorney.
Okay, Persante, to take that a little further, you don't just do questioning jurors, you do focus groups. Is that correct?
Right. So leading up to the trial, what we do is we bring in folks. We don't tell them which side of the case we're on, or even that we're lawyers. And then we hit them with issues, and then we find out where their mind goes. Because all you have to do is tell someone in a focus group, give them a few facts, and then find out where they go. I'm reminded of, it's attributed to Ernest Hemingway, but said the shortest story was for sale baby never worn. Now that's the entire story. Now your mind is figuring out what happened in that story, and you're filling in the gaps. So we use that to find out what common folks think about the case, meaning non-lawyers. I think all lawyers are somewhat distorted. Also, their language, as we try and explain things, we want it to be concrete, try and concretize abstract terms. And then the jurors will often come up with language that we can then use in the trial in order to connect with the jurors. And we're also trying to figure out what type of person would be very bad for our case, what type of person would be amenable. We're looking to get a fair trial. Let me mention another thing, that normally when we get the list of the venire, most judges will allow us to then have our assistants, associates, Google the jurors to find out if there's anything on social media. Some people don't like that. Some judges don't like that. Some are against it. Some prohibit it. The trend is to allow more and more of that so that you can look at a person's profile and find out, is this person predisposed against you? If you had a case that involved, somebody said police misconduct, I don't really handle those cases, but you go to that person's Facebook page and it's all, every bit of it is all about, you know, they like the police officers, then that is something that, you know, you need to know, because this person may be coming in with a bias. So we spend half hour or so trying to find out what we can, and then we begin questioning the jurors.
Can I ask a question? How much expense is involved in all that?
We do it on the cheap. You can hire professionals to do it, but we prefer to do it on our own. So we might say, we'll give you we'll do an ad on Craigslist. It says $75 a person, and we'll give you lunch and breakfast and have you come to a conference room and sit down. And then we give you piece by piece facts about the case. And normally the facts that we present are the worst facts against us. Everything is sort of slanted against us because we want to know what their reaction is to it. And then after a while, we can put in some of the more favorable facts. That doesn't cost a lot of money, but then at trial, it doesn't cost anything. Folks get on their computers, and let's say, you know, Mrs. Scarfaccio is a juror, you type it in, and then you see, you know, this, what this juror is all about. Is this somebody that you think you could resonate with?
And Judge Hammond, following up on what Bob Persante said, we actually built a mock courtroom in my office because we learned from an experience. And we bring in jurors a similar way. We put an ad out on Craigslist or different methods. We screen the jurors, we get a big sample. And the thing that I have found shocking in the mock trials, we always do a mock trial before a major case, is how the issues we think are important are not important. And so many times we have tried cases and lost 1 or 2 or 3 mock trials and then used that information for the real trial. But I think it's an invaluable tool for all young jurors, young lawyers, because it's amazing what jurors pick up on that us lawyers going into a first time have no idea. I think Judge Scriven would relate to that. I'm sure Judge Burgess, you speak to jurors after verdicts too, and have indicated sometimes their rationale is completely different to what lawyers think, right?
I do. I talked to all the jurors after the trial was over, just to make sure that everything was administratively done correctly, and they volunteer information to me. And I will tell you that in many cases, what the lawyers think the trial was about is not necessarily what the jury thinks the trial is about. Oh, Nigel, can you hear us now? Can you? We can't hear you, unfortunately. When we're able to hear you, we'll get you in the discussion. But anyways, the jurors have a very different view. I think a lot of that has to do with the fact that they're not trained in the law, and it's actually one of the good things about our democracy that we have that.
There's
So,
another big difference between our two systems, and that's that by statute, we're not allowed to ask jurors anything about their deliberations. They're not allowed to talk about it at all. If they were to do so, it's a criminal offence. They could be prosecuted.
we have a similar restriction against the attorneys. They can't chase the jurors down the hall and talk to them. I know from past experience there have been some attorneys after a trial who position themselves at the doorway of the courthouse, hoping to strike up a conversation with a juror, excused juror who was coming by, and I cautioned them not to do that. So let's go to another area of great misunderstanding. Americans think that there's only one English court system, and David Hughes, you've had some experience in several of these, including Gibraltar. And how many different systems are there in Great Britain?
That's an interesting question. In the island of Great Britain, there are two. There's England and Wales have a joint jurisdiction. Scotland has a separate jurisdiction. But there is, in the United Kingdom, there are three, because there is the Northern Irish jurisdiction, which is not on the island of Great Britain, but is part of the United Kingdom. Northern Ireland has a jurisdiction. When all of Ireland was part of the United Kingdom, there was a single Irish jurisdiction. When partition happened and the Republic became independent, those systems diverged. So the Northern Irish system is recognizable to an Anglo-Welsh lawyer. The Scottish system is very different. You've heard about the size of their juries. The terminology is very different. It's a more Roman-based system. Then you also mentioned Gibraltar. Britain has, I was just looking up, we've got a fair few overseas territories still. Some of them are fairly significant population-wise. The largest is is Bermuda. Then you've got places like Turks and Caicos, Cayman Islands, Gibraltar, which have populations in the tens of thousands. And then you've got tiny ones like St. Helena, which is split between several. The jurisdiction I can speak mostly about is Gibraltar, which is it's a city of just over 30,000 people. It's not technically part of the United Kingdom, but it's under British sovereignty. And what is interesting from an American point of view about Gibraltar is that although you're probably used to the idea that the United Kingdom doesn't have a written constitution, Gibraltar does. And I think all of the overseas territories do nowadays. So in that way, it's a more familiar environment for a US lawyer. And indeed, some years ago, I was involved in some litigation about the Gibraltar Constitution, touching on what we were talking about earlier about the composition of juries. Gibraltar at that time had all male juries. And in challenging the constitutionality of that, we couldn't find any case law from England and Wales that was really touching on the point. But as you will anticipate, we found plenty in the United States, cases like I think People and Wheeler, JEB in Alabama. You guys will know the cases. So you've got, in the United Kingdom itself, you've got 4 countries, England, Wales, Scotland, and Northern Ireland, 3 jurisdictions. England and Wales share a jurisdiction at the moment, although there was a report fairly recently calling for that to change. We also have our own primary legislature in Wales. So England only has the UK's parliament. So it's as if California only had the United States Congress, but was joined in a jurisdiction with, say, Nevada, and Nevada had its own legislature as well underneath that. But they still shared a court system. And then we have the overseas territories, which I've just been talking about. What we don't have is a federal jurisdiction. Obviously, we're not a federal country, but there are some tribunals that are organised on a cross Great Britain or cross United Kingdom basis. But the only court whose jurisdiction extends throughout the United Kingdom is the UK Supreme Court. So I suppose the real lesson here is when you're talking about any of the UK's legal systems, please do not call us English, because although most UK British people are English, the legal system that England has is the English and Welsh one, or the Anglo-Welsh one. The Scots have a distinct system, so do the Northern Irish. There we are. Hope that wasn't too long.
Now, are all the courts in Great Britain English-speaking courts? For instance, in Wales, are the courts in Welsh, or do they speak English?
The default language is English, but you have a right to use Welsh in the Welsh courts. For administrative purposes, you're asked to indicate that beforehand so that they can make sure you've got a Welsh-speaking judge. I've known cases to be argued in Welsh before a two-judge panel, one of whom speaks Welsh, the other has learnt some but needs the interpreter. And the Welsh legislation is now passed bilingually in English and Welsh as well.
Okay, thank you.
But I was just about to add that in Northern Ireland, you don't have the right to use Irish, which is a bone of some contention for some people there.
Judge Patrick, you had something to add to that?
Yes, only that David's forgotten that the Isle of Man and also the Channel Islands, so Jersey and Guernsey, they all have their own legal system as well. So we've got quite a collection fairly close by.
Right.
Indeed, and they are not British overseas territories. They are crown dependencies, so they're a different genre of thing altogether. Sorry about that. My apologies to them as well.
A mate of mine has just become a judge in Guernsey, and he spends half his time as a judge and half his time in the House of Parliament as the Speaker, which is an interesting job share.
Judge Colbert?
Yeah, I'm I'm wondering, so what does that do for licensing? So in America, you have to have a different license for every state. Now we have some reciprocity with different states. For instance, in Louisiana, after 5 years of practice and a passage of the NPRE, you can become licensed in the state of Texas, which is right next door. With you guys having 3 different systems already in that system, what do you do about licensing? Or you have to get licensed each one, or are you just licensed in each of them?
No, it's the way it works is it depends on each jurisdiction. If you are admitted as a lawyer in England and Wales or Northern Ireland and have practiced for 3 years, getting admitted in the other jurisdiction, i.e. for me to be called to the Northern Irish Bar, which I have been done, is administratively very simple. It's an administrative process, and then I had to fly to Belfast for a ceremony, but there were no exams involved. For Scotland, there would be exams involved because the underlying law is different, and it's I don't know how different Louisiana law is from, say, Texas law, but it's not something where I could go in and my familiarity with the principles would enable me to practice. It's a very different ball game. About the overseas territories, the only one I can really speak to authoritatively is Gibraltar. When I was admitted to the Gibraltar Bar, there was no exam involved. I just had to produce my call certificate from England and Wales, and then a month later I was in. Now there is an exam involved, and there's a year of training that you have to do, but that's done part-time while doing other things. So that's the way it works.
Now, in
The
the
interesting-
go ahead, Judge. I was just going to ask about the federal system.
Well, the interesting thing is Florida has resisted to the nth degree any reciprocity of admission of lawyers from any other state for any reason. However, we have a broad pro hac vice system in the federal system, so that any lawyer who submits to practice in the federal court can, as Judge Hughes's scenario suggests, just ask for permission to appear in the Florida court. And we have both foreign in the local sense and international law firms who open practices here in Florida just to allow their lawyers to come into court here who might have international or other expertise. And so while there's no reciprocity of credentialing, there's certainly reciprocity of practice as a practical matter in federal court, and to some great degree now in state court. But certainly in federal court, we see lawyers. If I did a poll of my cases, my guess is that 65% of the lawyers on my cases are from someplace other than Florida, who are practicing here on the civil side, not on the criminal side, but on the civil side.
Okay, thank you. Judge Patrick, is that a wig I see in the background?
It is. I thought you might. It's one of the two. This is the one that I wear every day.
Is that called a bob wig?
Yeah, well, it's a bench. This one's a bench wig, which is
Okay.
That's the day-to-day wig. I knew that would collapse. And then this is the ceremonial one, the full ceremonial one.
And how long do those wigs last?
This one doesn't get worn very often, so it lasts quite a long time. This one I wear every day, and it's beginning to show.
And do you get a stipend as a judge to pay for that and your robes and things?
When you're appointed, what used to happen was that when you were appointed, just before I was appointed, you would get quite a large sum which would cover all your robes, and that was it. But now you get given your one set when you're sworn in, and then you get another set after 10 years.
What are they made of?
I'm sorry?
What are they made of? Are they horsehair?
They're made, well, this one's made out of horsehair. You can get them made out of nylon, although somebody has just started selling hemp wigs made of hemp. And they are vegan friendly, I'm told, and that's how they're being advertised. So you can now get those. How long they'll last, I'm not sure.
What are judges required to wear on the bench?
The robe that, at my level, the robe that I wear is a rather like your robe, a dressing gown, and which fastens up at the front. I get a red sash because I sit in crime. I've got purple cuffs as well, and I wear with that a wing collar and then 2 white bands, and then a belt which keeps it all gathered in. So that's the criminal robe. If I were sitting in civil, then instead of the red sash, I would have a purple sash.
Now the judges in the Old Bailey wear black. Is that just?
They do. There are different judges wear different things. In the Court of Appeal and at the Old Bailey, the judges wear a special waistcoat and a black gown. When I started at the bar, if you were a High Court judge, so at the level above me, you would have 5 different sets of robes depending upon what you were trying and the time of year. And so you'd have different robes to try criminal cases in the summer and in the winter, different robes to try civil cases in the summer and the winter, and different robes for sitting in the Court of Appeal.
What's the organization of the courts in England and Wales, for instance? How many
from
lowest to highest or highest to lowest?
Well, in terms of criminal cases, the lowest court is the Magistrates' Court, which is where 95% of all criminal work is dealt with. And that's dealt with either by a full-time lawyer sitting alone or a lay bench of 3 magistrates who are appointed for life, until 75. I think now it's about to change from 70 to 75. And they sit in a panel of 3 usually. And so they do with.
There need only be 2 magistrates, lay magistrates sitting, Usually it's 3, but in busy benches they only sit as 2.
Well,
If
that's
they
right.
can't agree, they have a fresh hearing.
Yeah, well, at the moment, they're certainly here, they're trying to sit with 3. Anyway, that's the
Manchester, it's always 2.
The
It's always
next
2 in Manchester.
the next level is the Crown Court, which is where a judge sits with a jury, generally, unless somebody pleads guilty, when the judge only sits on their own. And then appeals from the Crown Court go to the Court of Appeal, and then from the Court of Appeal they go to the Supreme Court.
Do you have any municipal courts? Like traffic courts, things like that? I think they have those.
They would be dealt with by the magistrates. So they would have a designated.
What's the qualification to be a magistrate?
There isn't one.
So it's pretty much.
You'd have to be of good character, and I think you have to be now over 18. But those are the only.
Okay.
Those are the only.
Judge Colbert, you've got, what's the structure of the courts in Louisiana? I understand you do have municipal courts. We've done away with those in Florida. We just have county courts. But how do you organize?
Each individual town here actually has a city court or a mayor's court, depending on the actual population. The mayor's court, of course, or city courts, our lowest, they deal what we call misdemeanors, crimes which are punishable by less than 6 months in jail or a fine. From there, you go to the district court, which is what I am. I'm a district court judge. And the district courts hear all of your major felonies and your more serious civil case, depending on the dollar amount. And then from there, we have our Court of Appeals. And after the Court of Appeals, we have a state Supreme Court. So that's our pyramid or tiered structure that we use in Louisiana. And it's just how they want to go up. But except for the mayor's court, if the mayor sit, everybody's elected here. So when he says it's okay for anybody to be a judge if you're 18 and over good character, the requirements to be a judge is 8 years of practice and good standing before the bar, unless it's a mayor's court. And then, of course, you appeal to each one above that. So until you've been licensed and practicing for 8 years, you're not going to qualify to be a judge here at all, at any level. And then from that point, it's district, which is we call them parishes. Most people call them counties, but I sit over a 3-parish or a 3-county district. And then it's our appellate court, which is organized into a larger group of parishes or counties, some 10, some 12. We're a 64 parish state. So they divide that up into several different courts of appeals. And then there are the Supreme Courts, and they are elected across the state.
Judge, I wouldn't want you to be under any misapprehension. It's the magistrates who are a lay bench, who are 18 and of good character. If you're the judge alone in the magistrates' court, or if you're a judge in any of the other courts, you have to have criminal, or you have to have legal experience, and depending, either 5 or 7 year post-qualification experience.
Robert Persanta, you had you want to add something?
Just Judge Colbert, if you would comment on the fact that Louisiana, I believe, is the only state that's under the Napoleonic Code, and how that differs from other states.
Again, we call it the Napoleonic Code, which means all of our laws are codified because we have a constitution. It's based on old French law. It's what it's based upon. Everything is basically written down and case law. Whereas in the majority of other states, or the other 49 and territories, they're what they call common law. Their system developed over time, but ours is all codified. Everything you ever want to know about law Louisiana is written down, unless you hit the federal bench, then that's their own separate set of laws. But everything here is written.
You don't have to know French to be a judge in Louisiana, do you?
Not at all. I couldn't speak a lick of French if I tried.
I bet you can say etouffee.
I can't. I know how to eat etouffee.
Now, Judge Scriven, in our federal system, we actually do have a bilingual system. We have in Puerto Rico the courts at the Commonwealth level and up to the district courts are in Spanish. Bankruptcy courts, if I recall, are not their bankruptcy court is in English. Is that correct?
I am not sure. I've not ever considered what they are doing in the Puerto Rican court.
So how do the federal courts connect to the state courts in here? I know a lot of our English friends are absolutely baffled by our federal system. And
Well, our federal system is intended to be baffled to keep everybody out of it. But we have a system that's three-tiered, much like what you've heard described. We have magistrate judges who handle all of the pretrial matters in civil and often in criminal court, and they can act as Article III judges, which I am, which is an appointment for life, if the parties consent to have their matter heard before the magistrate judge in every area except for felony criminal. You cannot consent to a magistrate judge in federal criminal cases. And then the district judges are appointed for life by the president with confirmation by the Senate, which is the same as the circuit judges who are Article III judges and the U.S. Supreme Court, which is the highest court of the land. And so all of the matters are heard from soup to nuts in the district court, really. This is the workhorse of the federal system. Rarely do cases get to appeals, even though you hear about appeals more often, but most of the work is done at the trial level. And then you can appeal my decisions to the 11th Circuit, and you can appeal the 11th Circuit's decision to the U.S. Supreme Court. Now, we get connected to the state because if a person has exhausted, and certainly on a criminal level, every area of appeal at the state level, and they still believe their rights under the United States Constitution have been violated, they can then bring a separate collateral proceeding to the federal court known as a 2254 writ of habeas corpus, asking the federal court to intervene in the decisions of the highest court of the state level. And then they bring those cases in the federal court and they come to my jurisdiction for my review. Now, there's substantial deference to the state court determinations, factual determinations, and legal determinations, but ultimately it can come through the state court, through the federal system on the criminal side, and up through the 11th Circuit, and then up to the U.S. Supreme Court. And it was funny, when I first started, I was a magistrate judge years ago, and I told my daughter, we saw somebody run a stoplight, and she said, "Mom, is that man gonna come to you?" And I said, "No, your mom is a federal judge. I don't do traffic. That's for the state court judges." And the next day I got to work and I had my traffic docket, because we have a traffic docket that emanates out of any federal property. So if you run a light on MacDill Air Force Base, or you steal from the commissary, or you fish on federal property and don't use the right bait or trample a bird nest, those matters come to federal magistrate judges for consideration, as long as it doesn't hit a level of a felony. So it's soup to nuts in the federal system, but in a very sort of different way. And our judges the magistrate judges are appointed by the district judges based usually on a panel of lay people and lawyers making a recommendation of candidates. District judges are appointed by the president, as are Article III, 11th Circuit judges or circuit judges, and the Supreme Court.
Okay, so you guys from Great Britain, you got all that? Great, that's our system. Nigel, can you hear us now?
I can hear you.
All right, perfect. Just in time.
Can I just go back to the first question, please?
What's that?
Can I go back to the first question?
Sure. What I've got.
I'm joking.
Yeah.
I'll give you a potted history of what I would have said if you'd like to know.
Sure, certainly.
Okay, well, if I can go back to juries, I go back to the days of 1976, when you had 7 rights of challenge. And as you say, you could exercise them in any way. Somebody comes in reading a right-wing newspaper, as defense counsel, you challenge him off the jury. Trouble with that is, when you start running a sophisticated argument later, and you've got 12 blank faces, it hasn't always worked. I know that some people question whether or not the voir dire or voir dire in America might be as good as one would think. Secondly, so far as juries are concerned, and the questions that judges can ask, I mean, in fact, sometimes rather than change the jury, we change the venue. So if a case is particularly notorious in a venue. It may well be it's notorious all over Britain, but if it's not, then you can ask the court to move, and that helps. And as to jurisdictions, I've done a case in the British Indian Ocean Territory, which is owned by Britain, leased by America for its troops, and a High Court judge, Sir John Spry, was brought in from Aden to try the case. Okay, so there you go. That's a little bit of input from me. Better late than never, you may think.
Always welcome, always welcome. Judge Patrick, do you have something you want to add? Or you're just making a friendly gesture to Nigel? Robert Persante?
Yes, I was going to say to Judge Lithman that venue cases get changed for venue here as well. If a case is too hot in a particular area and it would be difficult to find jurors that weren't affected by it, it'll get moved to another state.
Right.
So that's the same thing. You know, the old joke used to be, just to go along with what you're saying, the old joke used to be that, you know, a jury is 7 members of common ignorance, because if they know anything about the particular area, they generally get stricken. Okay.
Yeah.
But, you know, the reality of it is that when you have that many people with that much, you know, diverse background, you usually get, you know, a good sound result from it. But I understand your issue is that if you get rid of the people that have knowledge, then who do you have left?
Yeah, there was one exception maybe that Judge Patrick would agree to. I don't think he mentioned it, which is that the judge actually gets a list of any special features that relate to a juror. So if they have medical difficulties, we hear about that. But also if they're serving police officers or ex-police officers, and if there's going to be an issue such as credibility of the police evidence, then you'll actually let that be known by defense counsel. And ordinarily, if they say that one side or the other objects to that policeman serving or ex-policeman, then I will strike him from the panel.
I understand that. I think David Hughes made this point last year, that there really are no jury trials in civil cases unless, for example, it involves police misconduct or something like that. In the United States, you know, we have a jury trial in every kind of case, unless it's pure equity. If it's pure equity in talking about civil cases, then that is a decision for the bench, for the judge to decide. But in any other kind of civil matter, in the circuit court anyway, you have a right to a jury trial. And David, did you want to comment?
Yeah, that's right. We there used to be a right of jury trial in defamation cases, but that was removed in 2013. So now the right to jury trial applies where you have a case that involves an allegation of false imprisonment or malicious prosecution. So as you can imagine, those are overwhelmingly police cases. Or if a charge of fraud is made against you in a civil case, you have a right to apply for jury trial. I've never known anyone to do that. Our juries are, as you heard earlier, 8 in the county court, 12 in the high court. Even where you have a right to jury trial, this is an area where I'm practicing a lot. It's not automatic that you would apply for a jury trial. It's quite a nuanced individual discussion you'd have with a solicitor in each case. And it's a qualified right. It doesn't apply, for example, it can be displaced where the case involves looking at a lot of documents or a technical or local examination. It's quite rare for that to displace the right to jury trial, but it can. And again, someone has to ask for it. Either side can ask for it if the case involves malicious prosecution or false imprisonment, but I've never known a police force to ask for it. It's when it's asked for, it's, in my experience, always claimants.
And
David, does the police have, go ahead, Judge Scriven, I'm sorry.
I was going to say, in the federal system, if the United States is a party in a civil case, you generally do not have the right to a jury trial unless the United States has expressly waived and agreed to consented to the right to a jury trial. Most of the cases involving the United States as a defendant in a civil trial, are heard by the bench. In police brutality cases, for example, where there is a tort involved, the United States has waived its right not to have a jury trial. That's why those go to jury trial. But in the vast majority of cases, if you get hit by a post office truck, for example, and you want to bring a civil case, if you can get to federal court, you won't be in front of a jury. You'll be in front of a judge.
Oh, wow.
Do the police in Great Britain or the United Kingdom have any form of immunity against lawsuit or prosecution?
I can't speak for Scotland, but the principle is that they are public bodies, including the police, are subject to exactly the same tort responsibilities as private bodies. The police have certain powers that private individuals don't have. For example, a police officer can arrest you for more offences than a private citizen can. But the police, when that happens, are under the same duty as a private citizen would be to be able to justify both the arrest and the entirety of any subsequent detention. And what we also have here is there's a special tort that can only be committed by people exercising a public power called misfeasance in public office. And misfeasance in public office is the exercise of a public power for an improper motive, either intending to cause harm or being reckless as to whether harm is going to be caused. And for example, if I'm representing someone who says they've been unlawfully arrested, I'll usually put in the claim false imprisonment, but we'll put in misfeasance in public office as well, in case we can't make out that. For example, a police officer may have a reasonable suspicion that somebody has committed a crime, but nonetheless arrest them for an improper motive because, for example, they don't like that particular person. That would be, on false imprisonment analysis, arguably lawful, but misfeasance comes in there. And what we don't have is, again, I may not understand your doctrine of qualified immunity very well, but we don't have anything like that. A police officer exercising their power has to be able to justify it by reference to law.
Judge Scriven?
Well, I can speak to qualified immunity because it eats up a vast majority of my time in resolving cases in the federal system involving officer conduct. And we do have absolute immunity for judges and absolute immunity for government officials like the mayor and the president and the governor for the exercise of their duties operating in their official capacity. Officers enjoy qualified immunity, and qualified immunity allows them to have immunity not only from liability, but from suit. And so if you sue an officer and he or she asserts their right to qualified immunity, you have to prove that they were operating essentially outside of the bounds of law. And they can argue that even if they violated the law and they violated your constitutional rights, that right was not clearly established by existing precedential law at the time they did the thing that they did. And even though they may have violated your constitutional rights, if it wasn't clearly established at that time, they're not subject to suit. And as for motive, even if their motive were wholly impure, they just really don't like you, but they can show that a reasonable officer in the same circumstances would have acted in the same way that they acted after the fact, post hoc, they're entitled typically to qualified immunity. And even if they have bad motive and they did a bad thing, but the law wasn't clearly established at the time, then they are entitled to be absolved from suit. And that's why the body public has a very hard time understanding when a, quote, police officer gets off, because there is a substantial level of protection designed to say, in the heat of the moment, in the effort to establish and preserve order, things can happen. And we can't sit in the, they say in the appellate court, sit in the cool, calm collection of your judicial office and review the behaviors made by law enforcement in the press of the work they're doing. And so we're not going to basically armchair quarterback police officers except in the most significant, obvious circumstances.
Can I make an observation there that just to contrast that? There was a well-known case from England and Wales, getting on about 20 years ago now, that illustrates the different approach. And in that case, a woman sued for false imprisonment, and she sued the governor of the prisoner where she'd been detained. She'd been arrested, she'd been convicted, and the Court of Appeal had determined that her release date on the face of the statute was X. In a subsequent case, it was determined that that release date calculation was wrong. So the governor of the prison had detained her according to what the law was understood to be at the time. Because of the declaratory theory of law that the Court of Appeal was declaring the law as it always was, or the statute as it always had been, that decision turned out to be wrong. Now, the governor of the prison couldn't have done anything else. Notwithstanding that, the governor of the prison was still held to be liable to pay her damages. Now, the damages were not very much. That she got £5,000 for about 2 extra months. But as a matter of principle, he was still liable to pay her the damages.
A question from our audience. What's the difference between a barrister and a solicitor? And it's from the Americans, if you're wondering.
A solicitor is the person you go to when you've got a legal problem, if you're a lay person. The barrister is, it's not technically like this, but it'll help you by analogy. Think of the barrister as a lawyer who is subcontracted by the solicitor to do certain things. Say you've been arrested, the police have arrested you, and you think they did so unlawfully. You go to a solicitor. That solicitor does everything that needs to be done in the case. He takes your statements, he writes to the police with a letter before action. He will instruct me, he or she will instruct me or someone like me to do certain things. And those will usually be to advise on the case, to say whether it's a good case or not, whether I'm willing to do it, to draft the pleadings, the formal particulars of claim that go to court, and then to go and court to court and argue the case. Now, most of the work that I do, and most of the work that most civil lawyers do, is in the county court, where solicitors have a right of audience. So solicitors could do virtually everything that I do. I can't do important things that they do. I'm not allowed to conduct litigation. So I can't engage in correspondence with the other side. I can't hold any client's money. Now, these barriers are breaking down. There are barristers who work on direct access. There are some barristers who are licensed to conduct litigation. I've been a lawyer in what we call a fused system, where the attorney, as you would term it, does everything. I did that for nearly 10 years in Gibraltar. The advantage that you have as a barrister is that I don't have potentially a dozen people coming into my office with a new problem every day. I don't have partners or bosses to whom I'm responsible for billing in a certain amount of money. I'm self-employed as a member of chambers in Northern Ireland. They have a library system, which is a different thing. But because I'm self-employed, if I want to take a holiday, I can do it. And because I don't have those other distractions, from the moment a case comes in, I look at it with a view to how I'm going to be arguing it in court. I hope that's a fair and adequate explanation of the difference.
To put it a little more simply, barristers are the trial lawyers, basically, who conduct cases before juries or county courts or high court generally. There is confusion of roles, but the solicitors are the generalists who deal directly with the public and prepare cases for trial by a barrister. That's the general impression. the general system. It breaks down at the borders, but that's what it is: a specialist and a generalist.
Are there separate educational tracks and license procedures for them, for solicitors
Yes.
and barristers?
Yes.
And what's a barrister is that one who goes through one of the Inns of Court? Is that what
Yes,
makes?
you're called to the bar by an Inn of Court.
What is the role of the Inn of Court and Inn of Court in the United Kingdom system? In our country, it's a voluntary association to promote professionalism. But as I understand it, the Inn of Court has much more authority in Great Britain.
I guess. The Inn of Court is the only people who can call a person to the bar, one of the 4 inns. And in Ireland, there's the King's Inns, and there's the inn in Northern Ireland as well. The Law Society is the body that makes licenses people to be a solicitor, which is the other profession. If you were, the Inns of Court have delegated many of their powers of discipline to the Bar Standards Committee. Committee or council, I can't remember it anymore. It's the Bar Standards Board.
Okay, now, if somebody is not called to the bar by an inn, is there an appellate process? I understand that there is one in Great Britain, a panel of judges, if I recall. Is that accurate?
Yes, I think it is. Although it's pretty unlikely, providing you've gone through the stages and have done the you've qualified, then the chances are you're going to be called to the bar. I think the appeal procedure generally is kicking people off for disbarring them. I think that's
I would think that's very rare.
Not as rare as we would hope. Let's put it that way. I think.
Do solicitors ever become barristers, and barristers ever become solicitors?
Yes, quite a lot. And there, somebody I noticed in the chat makes the point that there are some solicitor advocates who operate for all intents and purposes like barristers as well. So solicitors do appear not only in their own right in a lot of the courts, but they sometimes appear as specialists too.
Now,
it's quite common. It's quite common for solicitors to become barristers. I think it's less common for barristers to become solicitors, though it does happen.
Now, with Brexit, is there any formal connection between courts in Great Britain and the continent or any other part of the world, or has that been severed as a result of Brexit?
We have a judge. The United Kingdom has a judge on the European Court of Human Rights. Still, that's not a European Union body. That's a Council of Europe body.
Okay.
And there are judges on the. I think we have some UK judges still sitting on the Court of Final Appeal of Hong Kong. Do we not?
Well, the English are by origin. I don't know if they are still members of the English bar. Or English judiciary, but there are people who've been appointed to the Hong Kong judiciary from England and Wales and Scotland, and they sit there. Certainly the judges in Hong Kong wear identical robes to our circuit judges' robes when they're sitting at first instance.
Is there any advantage to having a split system between solicitors and barristers? What do you think, David? What's the main advantage?
I think there is. Having worked in both, they're different jobs. The skills that a litigator needs are not the same ones as a trial lawyer has. A litigator needs a sense of organization, an administrative ability that a trial lawyer doesn't necessarily need. I think you can be as good an advocate in a joint system, a fused system, as in a split one, but it's easier in a split system because the distractions that I don't have.
It's a point, I think, David, that you're making, that you can buy in expertise too on behalf of your clients. And I think that's a real advantage.
I think America would have gone that route, except that at the time of our revolution, we were too poor and too spread out. So we developed a unified system. David?
Yeah, it's interesting that I don't know of any jurisdiction that has lost a split system, but the Australian jurisdictions, for example, Northern Territory, acquired a separate bar just by people deciding that they were going to split from fuse profession and practice solely as barristers. That happened in the 1970s. Western Australia had it in the 1960s. So there are, although the states on the eastern coast of Australia, the more populous states, have long had separate bars. Separate bars have developed in other Australian jurisdictions. And it's quite an interesting phenomenon.
So let me ask Robert Persante and Roger Feudeman, what do you think? Would you like to have a separate split system, or are you okay with the fuse system?
I'll start with this, that it's kind of like Bill Parcells said when he was a coach of the Cowboys, where he said, if you want me to bake the cake, I want to choose the ingredients. So what happens is, as trial lawyers here, we're involved from start to finish. We meet with the clients, we meet the witnesses, we build a case. We have a view of what the trial is going to be like, and we go out and get it all. But as David says, we've got all the headaches of managing a firm and dealing with all of that, and dealing with money and fees and, you name it, retainers. I love cases in which somebody brings me in to just try the case. I do like that, but I have to have confidence that the person that put that case together really knows what they're doing. Because without preparation, I don't care how brilliant you are, you're going to have a problem. Okay, so and I think that barristers like David are skilled at really looking at it and seeing, number one, he probably knows which solicitors put the cases together well, and then has a keen eye for how good this case really is in terms of trying it. So my preference is to be involved all the way through, although I have plenty of cases where other lawyers have put it together, and then I get in on the tail end to assist at trial or to lead at trial. I did have one question though, and that is, as a barrister, are you allowed to interview witnesses? Are you allowed to do that sort of thing? Or do you just get a brief or a bundle and you have to operate from that?
We don't interview witnesses. I will almost invariably have a conference with the client before a trial. I will often be brought in, because of the nature of the practice I have, I will usually be brought in at a fairly early stage. And I'm lucky that most of my work is from solicitors who really know their stuff. And yeah, the cases will be well prepared. It can be an issue in other practice areas. I would usually see the client before a case, but in a conference, but I wouldn't expect to see witnesses, save perhaps an expert witness. And we certainly wouldn't be allowed to do any kind of rehearsal of what their evidence would be.
One interesting concept, which is very foreign to the American system, following up on Judge Burgess's question, which I do think it encourages professionalism and cordiality, is the way in the British system, 1 week you may be arguing for the Crown, and 1 week you might be fighting like hell for your client as a defendant. We don't have that concept where next week the US government is going to ask me to argue in front of Judge Scriven on behalf of the government. I will always stay on the further side from the jurors arguing for the defendant. So it's a nice system to have in the UK, because I think it does breed a lot of cordiality and professionalism. We have a little bit more, a little less contentiousness, I think, which is nice.
I would say that in effect, we do have a split system in the U.S. Certainly from my vantage point, we clearly have a split system. 93% of cases in the U.S. system settle and do not go to trial. So only 7% of those cases in this federal system are coming to trial, which means only 3 to 4% of lawyers have any trial experience at all. Certainly on the civil side, and often on the criminal side, where the plea agreements resolve all the cases. And so it would not be unusual for a litigator to litigate a case for 3 years and then call someone like a Mr. Persante or Mr. Friedemann and say, can you come in and help me try this case? Because I don't know my way around the courtroom. I couldn't find the conference table if my life depended on it. And so we do have a split system in that respect, where lawyers just don't have trial experience, and so they have to rely on those really high quality trial lawyers to come in and take up. And I will say that I have had the pleasure of helping to train some solicitors who've come to the States to get trial experience through NITA or through a course offered by the local college here, University of Florida. And the solicitors are at least, I don't want to say anything to insult my American colleagues, but 80% better prepared to be trial lawyers than our litigators are, because the level of skill set that it even requires to be a solicitor. So the transition in England is not as great, I think, as it is in the US.
Right. Judge Lithman, can you hear us? Because I have a question for you if you can hear us. No? Let's go. Let's wait to see if we get that connection. And
it's checked now, Bill.
Yeah. Judge Lithman, can you hear me? No? Okay.
Yeah, you can.
Now, we can't hear you, Judge Lithman, but I'll hold that question. How are your court systems funded? Start with Judge Scriven. How's the court funded? Federal
The court is funded through tax dollars. There's an allocation of resources to the administrative offices of the court, and those monies are allocated to each of the circuits, to each of the districts, and we are fully government funded, from the chairs we sit in to the proceedings to the cost of jury expenses and so forth.
Judge Patrick, is that the way it is in your court system?
Yeah, almost exactly the same.
I'm sorry?
Yes, it's almost exactly the same.
Okay, thank you. Now, Judge Colbert, I understand in Louisiana, you have a slightly different system.
Yes, sir. We probably have what I would consider a hybrid system. While the legislature allocates some monies to fund the court system, the majority of the funding for the court system come from fines and fees that are collected from defendants, or from court costs, which are levied against people for filing actions in the court system, which, again, I disagree with that entire system. Because it almost incentivizes the court system or the police departments or to charge more, or to fine people to fund the system that they're receiving their paychecks from. So it makes the courts dependent upon the fines and fees, which 9 times out of 10 are those people on the lower socioeconomic scale who find themselves before the court.
Let's talk about a major issue that's been with us around the world. How have the courts adjusted to the COVID pandemic? And Judge Scriven, I want to start off by asking you about a Zoom trial you had, if you can tell us about that.
Yes, I had the pleasure of trying the only case that I know of in the federal system here in Florida by Zoom, completely by Zoom. The only person who came in the building was myself and my courtroom deputy. The jurors were all summoned to appear via Zoom. They appeared from their homes on their cameras, just like we have the Hollywood Square set up right here. The lawyers appeared remotely from their offices. The witnesses appeared remotely from the lawyers and from the court, and the entire case was tried over a 4-day period via Zoom. And it was a really great sort of social experiment. It worked seamlessly, and we got a verdict. The jury reported their verdict through the Zoom app and emailed it in to our court system, and no one ever stepped foot in the courthouse. Now, I will say it was sort of a made-for-TV type of trial that was intrigued. It had to do with the question of whether a man had killed himself or accidentally overdosed, causing his death, having to do with the wife's desire to get an insurance policy. So, the jury was riveted to the screen. I had my law clerks responsible for observing the screen the entire time to make sure the jurors were paying attention. But other than one gentleman had a little bit of difficulty initially toggling between the courtroom, in air quotes, and the jury holding room by going into a private room. Once we got that worked out with him, we were fine. And it was a 4-day trial, very well run, and it went off without a hitch.
All right. Roger Feuderman, what do you think about a Zoom trial? Is that something that would appeal to you in your practice?
Well, I tried a case during COVID next door to Judge Scriven in front of Judge Honeywell. In fact, we were there till 1 o'clock in the morning one night, and we had to try the case with masks on and behind screens, and the jurors had screens. And I said, it ended up in a hung jury, but I said after that, if I can avoid it, I'll never try a mask trial again, because I don't think it's helpful to the defense. I think jurors are a little bit more tense. Everyone's in a worse mood. I think it's much harder to get a successful defense verdict. And so I don't know if I could go as far as Zoom in a criminal case, but I will tell you that I believe it's not advantageous to the defense to try with masks on and screens and all the other barriers that we had to go through. Everyone was extremely accommodating, and everyone got through it, and it was successful in that respect. But I think it's challenging, because I do think to be successful for the defense, especially, you want a happy jury, and when they're all wearing masks and then their little plastic boxes, I don't think it helps. So, but I love that story by Judge Scriven on a Zoom trial, and it seemed like it works well. And I have found the only one benefit of COVID is that in state court here in Florida, we allow depositions. And now everyone's transitioned to depositions by Zoom. And it's so much more enjoyable as opposed to have people travel hours sometimes, and then sometimes the witnesses don't show. We can all sit in our offices, the witnesses, the lawyers, and really conduct depositions much more efficiently by Zoom. So I think that's been a tremendous advantage of the COVID, in that we have learned some things, and Zoom depositions are not leaving us. I know, Judge Burgess, you now do a lot of your court by Zoom for non-necessary hearings, and so I do think we can learn from this experience. Zoom is a great thing that probably but for COVID we would not use in criminal cases. In fact, we just did a sentencing on Tuesday. I did a federal sentencing by Zoom, and it was fantastic. And so I'm a great believer in Zoom, but I'm not sure if I'm yet as far as a criminal Zoom case.
All right, Judge Patrick, let's test your belief system. What do you think about all these Zoom?
We've used Zoom a lot for interlocutory stuff, but not for trials. Certainly I'd be a bit hesitant with trials. It's becoming more common for people to be giving evidence remotely. That works quite well. I'd be concerned about the jury management. We don't have quite the same degree of support, I think, in courtrooms, so I'm not quite sure that we'll be able to replicate that. But certainly an awful lot more now is dealt with remotely. In terms of trials, we started doing trials again. The first trial post-COVID was in June of 2020 in my courtroom, and to begin with, we were doing only one trial at a time, but we picked that up. We put in a huge amount of perspex. And so the jurors were in their little perspex coffins, and everybody was separated by perspex.
In my division, we've done hearings. We've never done trials by Zoom. We've done changes to plea. But let me ask Judge Nigel Lithman, do we have you? Can you hear us? We can't hear you. God, I've got. Is your volume up enough?
Is it close enough to speak on?
That's too bad, because I have a lot of questions I want to ask Nigel here. But okay, let's Judge Colbert. You have to unmute yourself. There you
Right.
go.
I want to say, and I'm probably the newest person to the bench here, having been elected last January, not the one just passed. But prior to that, when COVID first hit, I was still a prosecutor. So I kind of have that still nuanced feeling for doing it both ways. When I would never want to conduct a trial by Zoom, and as a defense attorney or a prosecutor, I would never want to conduct a trial by Zoom. We were speaking earlier about the nuances of conducting a trial, the different skills that it takes to conduct a trial. as someone who has chosen several hundred jurors, I would say, that is something that is done by touch or by feel, by realizing and watching people's reactions to certain questions. Well, given our system, doing it by Zoom makes that very, very difficult to pick up on those small, minor cues, those body movements that people make over Zoom. Additionally, again, the platform for us is just not that reliable. That's probably our internet fault. But even conducting a trial by Zoom just hasn't actually worked for us, given those nuances. Because one party or another party can never really see a person's quote unquote physical cues that they are giving to an actual question or an answer. Additionally, in Louisiana, unlike most states, we are not allowed to conduct depositions in criminal matters. So when the attorneys walk in, either defense or the prosecution, one side may have spoken to a witness, the other side may not. And so you're walking in cold turkey, so you never know what that person is going to say unless they've issued a written statement when the matter first took place. But since we can't conduct depositions, we have no record or no advanced knowledge of what they're going to say. So doing it by Zoom, I make it akin to doing a trial by ambush. Because again, you have no feel for that particular person.
I
No,
think
go ahead.
I think it depends on the skill set of the lawyers, not whether they're skilled or not, but their particular skill set. I would suggest that a lawyer who is not interested in sort of moving around the courtroom, taking over the space, if you just have a case, you have the law, you have the facts, you present them to the jury, let the jury decide, your case is probably triable by Zoom. But if you need a little bit of energy, you need the parties to kind of pay attention to the lawyer more than they're paying attention to the facts, then I think you don't want to have a Zoom trial, because there are virtually no theatrics to be had in a Zoom trial, because all you see is what you see right now, head and shoulders, and that's it. And I think for lawyers who need a little bit more, it's a difficult place to be. But I think you get to see the jurors closer. You see them as close as you and I are looking at each other now when you're picking a jury versus them sitting in the back row or in the back of the courtroom. And I thought it was advantageous to the lawyers to be able to see the jurors and their reactions. It was certainly advantageous to me to get a view of the jurors up close and personal.
Judge Hammond, we have a question. What is a recorder? Most Americans have no idea in the faintest what a recorder is, and I understand it's a very important role in your judicial
What a recorder is now, generally speaking, it's a part-time judge. They have all the powers of a judge when they're sitting, but when they're not sitting, they go back to being either a barrister or a solicitor. That is basically what a recorder is. We have people who are honorary recorders. I think I put a little bit in at some stage, a little bit about the history of recorders, but people can be appointed by the local authority to be the honorary recorder of the borough. That's usually the senior resident judge in any particular Crown Court. And now the tradition's grown up of them wearing a red robe and not a purple robe. And they are, it's a title, but they're still full-time judges. But the recorders generally, as I was and as the others were people who were members of the bar, appointed to be a judge by royal warrant, and sitting part-time. I think in my day, we had to do 28 days a year. And the rest of the time, we were barristers or solicitors in private practice.
Let's see if I can get this. Yeah, it helps quite a bit. Judge Lithman, can you hear us now? This has been a recurring theme during our discussion, but we're not going to give up on Judge Lithman here. What about Judge Hammond? What about a coroner? In Florida, we have a medical examiner system. In Louisiana, for instance, they still have a coroner system. What's the origin of the role of the coroner, and what does the coroner do in your system today?
day, but the coroner presides over an inquest, which is an inquiry into suspicious or unnatural death. It's necessary these days because of the Human Rights Act that there must be a proper inquiry into death because without a proper inquiry, you're not safeguarding the right to life. And so it's become quite formalized in our system. But the coroner itself goes back to medieval times when the coroner's principal job was to keep an eye on the sheriff and the bailiffs to make sure that the crown got its share of the proper share of whatever was being generated in the way of income. So looking after the royal finances, but they did acquire under the Norman kings the duty to investigate death, principally because if a Norman was killed, they wanted to make sure that the rights of the Normans were being looked after, I suppose. But it's long been the duty to investigate. The coroner is an investigator, not a medical examiner. Medical examination is carried out in our system by a pathologist, who is a medical man, who determines, at least gives evidence, as to the medical cause of death. I think that's as quick a summary as I can give about coroners.
And the word coroner comes from the Latin word for crown. Is that?
Corona, yes. It's a crown officer.
Okay. All right, great. Nigel Lithman, can you hear us? I'm gonna ask Judge Hammond a follow up to that. What do you think is the biggest challenge to the legal system in Great Britain today? What's happening with the system? We read about different things about the what appears to be underfunding of barristers and so on and so forth. What can you tell us about that?
Asking me? Well, it does seem that my daughter was a barrister, having been formerly a solicitor. She's given up the bar now to become a full-time lecturer because they quite frankly, such fees as they acquired from the legal aid system were being cut back and were totally inadequate to keep the bar funded. I think Judge Lithman would know better. He's been a chairman of the Criminal Bar Association, we've reached a situation in the last 10, 15 years where the bar has more than once threatened to go on strike because it's not being properly funded at all. There's very little in the way of work that is privately funded at the criminal bar. Things are different at the civil bar because it's insurance companies and trade unions that fund people in the main. But at the criminal bar, which depends entirely or almost entirely for funding from the public purse, it's been cut back and cut back and cut back.
I think
there are other issues which my colleagues who continue to sit can tell you about, but there appear to be inefficiencies in the system generally, getting cases on for trial.
All right. Judge Lithman, can you hear us? Go ahead, Judge Patrick.
Yeah.
There have been some significant cuts in funding for the police, so that investigations are taking longer, and fewer people are being prosecuted. There are significant cuts in funding. Criminal legal fees have not kept up with inflation, so lots of people have had to leave the profession. So that we've got fewer people scrabbling around to do less work.
Can you hear me at all?
Yes, Judge Lithman, we can hear you. I have a.
Oh, good, you can.
Now that we've got you finally,
let
me ask you. I understand the barristers in England have gone on strike once every 400 years, and you had something to do with it the last time that happened.
That's right. Yeah, I was chairman of the Criminal Bar Association that was in conflict with the government. The minister was called Chris Grayling. He was nicknamed Failing Grayling because he didn't have a great success record. And he was constantly cutting our fees and putting and cutting the input into legal aid. And in the end, remarkably, criminal advocates were earning the equivalent of less than $100 for a day. And that was unacceptable. He said he was going to cut it further. We said we would go on strike. The way we chose to do it was to say that we would have half a day strike, then a whole day, and then 2 days, and we would bring the process to a halt. He accepted that that's what we were going to do, and the government caved in. So that was cut. Now we've got, can you hear me, by the way?
Yes.
Okay. So the position we're in now is that because of the rather ridiculous things they often do, they decided to cut court sitting days in 2019. And that then went into COVID, and between them there was an enormous backlog. And because the wages haven't increased for the criminal advocates, the advocates themselves have left the system, about 15% of them in the last 3 years, and they are threatening that they will go on strike unless their remuneration is improved. And it's quite clear that's what they're going to do.
What do you think the biggest challenges to the legal profession in Great Britain is today? Is it that sort of funding lapse?
Well, I think it's two things. Number one, with the criminal justice system will collapse in terms of ability unless more money is put into the system. And I think, and so far as there's a massive backlog, about 60 or 70,000 cases due to be heard in crime. And I've always thought the answer to that is that everything, I know you were talking about Zoom hearings, other than trials, anything that can be done by way of remote hearings should be done remotely. That then clears out the court just for trials, and that will help on the backlog. And if the government will bite the bullet and actually put in the remuneration that's been recommended by an inquiry, then that will go some way to assisting as well. But it's a parlous situation. You just hear so often so many people saying we can't afford to stay and do a job that largely survives on the integrity of those that do it, and people giving up hour after hour, et cetera, So there we go.
All right, we are unfortunately, at the end of our time here. I'm going to ask everybody if you have any other issues you want to discuss before we bid farewell. And Judge Lithman, I'm going to ask that we set up a separate Zoom session with you. It's unfortunate we weren't able to get you in here with good connections, but I promise next time we'll do that. Anyone else have anything they want to address before we close? Robert Persante?
Say on the lighter side that Horace Rumpole used to say that the doors to the courtroom are open to everyone, just like they are at the Ritz.
All right. Anyway, I want to thank you all for attending. This has been a very interesting session. We, of course, have run out of time before we run out of topics to discuss, and hopefully we can rendezvous. And yes, Judge Scriven?
I just want to say that anyone who is open to the possibility of a Zoom jury trial, I have an entire preset package I'm happy to send you to let you know how it's done. That's the listeners on the call or the participants on the panel.
All right, I want to thank you all and wish you a very good day. And I certainly learned a lot listening to it. I think our viewers got their money's worth, and hopefully we'll rendezvous again someday. And if in the meantime there's anything I can ever do for any of you, don't hesitate to ask. Thank you all, and have a good day.
Judge Burgess, and thank you, Clerica.
Thank you, all of you. Good night.
Bye.
Hi,
Oh,
Joe.
Nigel, how are you?
Yeah, good. Can you hear me?
I can hear you loudly and clearly. And just to give you a little background, what we're going to do is take this portion of the Zoom across the Atlantic program that we did, it's all going to be part of the same thing.
Okay.
You tried valiantly to participate. I admire your determination. A lesser man would have given up a long time before that. And I want to make sure that you have a full opportunity to say whatever it is that you want to say. I've got a bunch of questions for you, and actually, this will work out because I'll be able to ask some questions in more detail than was permitted. So, but before we begin, Kelly is gonna hide her screen, so it'll just be you and I on this part of the video. But how much of the main program did you hear?
Yeah, quite a lot. Quite a lot.
And you're still willing to come on Zoom and
I thought it was different. I'm so tact awful. I'm not sure if I can show you, but I've got a wonderful bust of Lincoln on a desk over on the right hand side of my study.
All right, there it is. Yeah, very good. Excellent.
Yeah. It's gorgeous. Put it in here.
You'll have to once we get talking, I'll ask you about the history of that. Nigel, do you want to start a little bit early?
Sure. Bill, can I tell you when we start about my drinking coffee incessantly?
That's okay. If you want to drink coffee, that's fine.
I'd like to tell you about it.
Okay. So you're saying, Nigel?
Yeah, Bill, I just thought I'd start by saying, or continue by saying, you'll very rarely see me without a cup of coffee. I've got one now. And that's been the same throughout my career. One thing I should tell you about, I think that hasn't been covered so far, is that a silk gown includes a lapel that is about 3 inches wide, and it flies open. A barrister's gown consists of one important factor, which is a slot in the back in the material into which money could be placed. And in the olden days, that's where money was placed, a guinea at a time, to keep your counsel speaking. But now part of the silk gown is that he has these lapels that open up very adequately, and into which I would hide my cup of coffee and bring it into court. And I suspect you'd have me electrocuted in America and placed on my bench so I could drink it happily during the day. And therein lies part of the conflict between me and the judiciary when I was in practice.
I see. All right. Well, let's begin. Despite the fact that you tried mightily to participate along with everybody else in the Zoom across the Atlantic, the gods of communication and internet were not with us. So I wanted to have you on so that we can talk about all the very important things that you have to say, and I think you've got some great insights. One of the things I wanted to follow up on was that towards the end of our program, we talked about the state of the British legal system. We touched on how the courts were funded and a little bit on how barristers are paid. And if you can use that as a segue to discuss what is going on with, and in particular, the criminal courts, what's going on with the right to counsel and the ability of barristers and other lawyers in Great Britain to earn a decent living these days.
Oh, well, still a blessing, isn't it, of a democracy, is so far as you can, education, health, and justice should be available to all. From time to time, it's right, of course, that better justice sometimes, or better health, or better education becomes available to those that are able to pay, but there should be. And in the UK, there is proper and good access to counsel as part of the judicial process. But because a lot of what they do, and it's the same around the world with any profession that's based on integrity, is based on their being willing to go the extra mile for less than the extra pound. That they have become the target of government cuts. And so when it's said that the criminal justice system is being cut, what it really means is that the remuneration of counsel is being cut. And it reached a stage when I was chairman of the criminal bar in 2014 that it was down to rock bottom. And although I was able, with the backing of the criminal bar, to stop it being rotted further, the system didn't improve, and the remuneration hasn't improved. And so the difficulties still remain. And the tasks that are called upon, the everyday tasks, bringing up children and the like, have remained exactly as they are. So the criminal justice system, I'm afraid, remains what I call in a parlous state. And to say otherwise is just not to face reality. I mean, I'm aware that during the part of the conversation, I was trying my best to get involved. It was being said that the way that the justice system adapted to the pandemic was really, really excellent in the erection of perspex screens to divide counsel from witnesses, so on and so forth. But the truth of the matter is that although a lot of screens were provided, the judges didn't have screens. And the witness box from which a defendant, for instance, would come from prison, which would be riven with COVID, go into the witness box would not have protection by way of perspex. And I, who've never been shy at all to express my views, simply said this is just not good enough. We are vulnerable as older members often of the community to COVID, and we expect the minimum protection that is afforded to those that are on the cash desk in supermarkets, which is done perspex. And I was told, well, I'm sorry, you can't have it. And I said, well, there's no way I'm working without it. And I bought my own. And so for about $500, I paid for my own perspex. And it's important that we do recognize the truth of these matters. So can I just move on a little to broaden the argument to this? My career path was through being a junior barrister to Queen's Counsel. And then rather than retire, I decided to go and see a different job and go on to the bench. But as many Queen's Counsel did, I did rather well in my job. And not only are counsels chosen and paid by the legal aid fund, by the government, which is the situation and the parlous situation I was describing before, but they're also paid privately. They are guns for hire. And so because of that, life had gone quite sweetly for me in terms of the success that I was able to garner in that time. But as such, I had an amount of clout. The Ministry of Justice knew that I wasn't particularly perturbed if I spoke my mind, and I always did speak my mind. My view was that to not have perspex was not appropriate. And so when they said that they would not put perspex around the witness box, the box in which the defendant comes forward to give his testimony, I said, in that case, we won't use the witness box. And so in my case, people were standing 10, 12 feet away, further away than the witness box, in order to provide protection. So what I'm saying in a long-winded way, as usual, is that actually to hear that the criminal justice system is well funded, that we dealt well with lockdown is not always the full picture. And we should recognize, however wonderful British tradition, ceremony, and the like is, that does not necessarily tell the full story. So, take it from there.
What's been the long-term effect on the ability of the legal profession in Great Britain to attract and retain talent?
Yeah, well, the talent goes right up and down the spectrum, and I'm sure as in America, there are a lot of very talented individuals. They've worked hard, they've demonstrated enough talent to get to the position, even on the bottom of the rung. So what happens to them is that they then, who rely on government paying, are simply unable to deal with it. And so they will often be siphoned off to work in industry or elsewhere as in-house counsel. And that is a real loss to the bar and to criminal solicitors.
Mm-hmm. In 2014, you led a strike that seemed to be fairly successful. Have conditions gone back to what they were in 2014?
Well, what happened was that because I then carried on after my period as chairman of the organisation, I then went back to practice for another 3 years. And then as I reached the age of 65, that's when I decided I would spend the last few years on the bench. And so I took my eye off the ball because it wasn't my ball. So I didn't need to keep an eye on it. But what I've come back to immediately after, which is made in one sense, a fortuitous basis to launch the book that I wrote, although that did that, in fact, the state of remuneration had deteriorated as prices of inflation had risen. More and more people had less, and there became this infamous backlog of 60 to 70,000 cases. And what happens is that the Ministry of Justice comes out with a series of observations about how they're going to deal with the backlog, but they seem to be terrified to put their finger on the simplest solution, which is give the people who are involved in it a living wage.
Mm-hmm. I see. Now, part of the list of proposals that I read about were things called Nightingale Courts, which as a foreign observer, I assume that would require a lot more overhead, a lot more payment for the services of attorneys and so on and so forth. I haven't heard very much about the Nightingale Courts. What's happened with that? Did they ever happen?
Well, some of them have been constructed, parts of buildings have been adapted, and in a way that is COVID compliant, and that was the purpose of this. When I go back, I'm going to visit the court I sat in tomorrow, and I am sure I will find exactly things as they are. There are enough courts. You did not need Nightingale. Nightingale just the expression Florence Nightingale in order to imply something coming to the rescue of the criminal justice system.
I detected that when I was reading about it. And I was thinking of Florence Nightingale.
Yeah, that's what it is. Yeah. Well, rather than a lady with a lamp, there's supposed to be judges with lamps that light the way for the trial to justice. But it doesn't matter. However many courts you build, you need the people to man them. And at the moment, that is what's come round to bite the government in the pocket, which is that they simply realize now that they have not got the personnel to run the system. And until they do properly account for it, it's going to go back. So things are not great in the state of Denmark, or in this case, the state of.
So what do you think is the best solution at this point? You're at a point where the money does not appear to be sufficient, and the personnel don't appear to be sufficient. How do you deal with the backlog in an effective way that preserves the rights of the citizens of Great Britain under the Constitution and the law that has been in existence for centuries?
Right. First of all, Bill, can I thank you for giving me this further time to amplify my thoughts, particularly that intrudes on your personal time. So I'm very grateful for that. But I, for a long time, have said that there are two quite straightforward ways to deal with the backlog. The first is to take out of the court themselves those matters which can be dealt with remotely. And that would mean that all of the preliminary issues, other issues, through to even in part, as you were discussing the other day, through to sentencing, if they can be done remotely, they should. Because that enables the criminal advocate to double or treble up on the work that they're doing from the same place. So they don't have to travel to 3 different courts needlessly, but they can deal with the 3 cases in one go. The other advantage is that in this country, when a defendant comes from prison for the day, and it turns out to be needless, not only has he had to get up at 4 or 5 o'clock in the morning to start his travel, which has taken halfway around the world, to end up 2 miles away from where he started, but he might end up being taken back to a different prison from which he came. So there's every reason to convenience that. And so that if you actually take out those issues that can be dealt with remotely, that then frees up the court to do the trial. Because I heard your discussion about how effectively a trial can be done remotely. There are big question marks over it. In the UK, it's really been said that it really is enormously difficult to do, and we're against doing it. And that means just stick to doing those cases in court and stick to doing everything else that you can remotely. This was the song that was sung by the senior judges in 2015, but for some reason it seems to have gone backwards, and I think I know the reason for that.
So if you had to pinpoint the resistance to doing remote hearings for those sorts of non-essential matters, for instance, in our division I have, anybody can appear by Zoom if they want to. We have not done a trial by Zoom. It's not my intent to do it that way because of the rights of confrontation, so on and so forth. But we've done changes of plea by Zoom with the defendant in the jail and the lawyer in another city and the prosecutor in another part of the courthouse, and we've developed a system to do that ensures the integrity of it. Where, if you had to point to a specific place, where is the resistance in Great Britain to moving into that sort of a system?
So can I just ask, do people who listen to me now realize that this part of our discussion has been just between the two of us?
Yes. Because
I think it's good that I'm in the safety and security of my own home with my wife to protect me because of what I'm about to say. And that is, I'm afraid that my view is that a lot of judges, not a whole morass of them, but a lot of them have a contradictory view about almost anything that is suggested that can be viewed to be efficient if it works in the favor of the convenience of the advocate. Now that is an anathema to say that. That is one of the great unsaid, but it's true. There are cases of judges who are sitting in quite remote places on the coast of Britain who are wanting to start their court at 9 o'clock or 9:15. How is somebody going to get from London to their court at 9:15? It's impossible. Mm-hmm. But nevertheless, that is what they do. So it could be said to be bloody minded. And I'm afraid there is an element, and it might really upset people that I'm saying this, but there is an element of bloody mindedness in judges that say, when he or she says, I have said I want you in this court, and you will come to the court. But I've got a child, and it's easier for me to stay at home, and I can do the same, and then I can do 2 other cases at the same time. Well, why should you be earning? Why should all of this? It's not all about you, Mr. or Miss Counsel.
Mm-hmm.
but I'm afraid it is all about them in part, their convenience. So really, the resistance has come, I'm afraid, from the judiciary, and there has come statements now at last from the Lord Chief Justice saying that this resistance has got to give way to the idea that what can be done remotely can be done.
Right. Well, it's the same in every country I've looked at. The judges are of different minds in different venues, and I just happen to be one who advocates that we do things remotely, especially during the pandemic. We actually had advocates up here who were in COVID quarantine. And in order for them, and one reason that we did it the way we did it was to try to give them a chance to keep earning a living by doing that. But that's where we're at. I'm hoping that the situation will clarify with our state Supreme Court in the next few months when they revise some of their rules. So that having been said, let's go to another issue, if I may, and that is how much of a problem is judicial bullying in Great Britain, in British courts? Is that I've read things here and there, and of course, you never know by whether an article or a comment is representative of anything other than that one incident or a person's view. But what has been your experience with that?
My experience is that it is it's a disease, but it's not a pandemic, and it still exists amongst some judiciaries. I put it down to a lack, perhaps, of self-confidence or happiness in their own lives, a tension about the fact that they believe they should have risen higher in the judicial ladder than they have, and perhaps that they are, when they have a tilt in front of them, a Queen's Counsel in front of them, they know they have somebody who is prepared to take them on and is prepared and is probably in a happier position in their professional life than they are. So I recount in nothing like the truth. I'm sorry, I will come to books, but then I'll stop. I gave an example of how when I was told by a judge in the middle of a submission to sit down, and I couldn't believe my ears. And I said, I'm sorry, I don't think I heard you correctly. And he said, I've heard what you have to say. Sit down. And I just rose to my pompous height and said, I've been Queen's Counsel for 18 years. I know the difference between the moment when I should stand and when I should sit. And this moment is one where I should stand. And when I've completed it, I'll sit. And so that's how we continue. But if I was to say that he spoke to me as if I was a dog, then that would be really offensive to what the dog thinks about.
So what's the difference between a good British judge and a not so good British judge? I know there are absolutely no bad British judges. I've met nothing but good British judges. But in your experience, what is it? What characteristics cause a judge to stand out as being most effective, best to appear in front of, so on and so forth?
Yeah. Well, the end result, the end definition of who's the best person to appear in front of is when the criminal advocate comes to court, sees that they're in front of Judge Burgess, and says, my day has just got better. As opposed to when they come to court and they see that they're in front of Dr. Big Judge Lithman and say, my day has just got infinitely worse. So what you have to find out is what is it that makes them say that Judge Burgess is such a pleasant tribunal? It's because he recognizes that the task that the defense counsel, or both counsel has, is difficult enough, that they have spent lots of time preparing their work, and they have got a difficult enough life as it is. But they will be that they will be, that is, you will be kind, polite, and when you deal with the defendant, humane, and all of the same rights and decency that you expose to everybody will be shown to them, and there will be a calm in your court. Now that doesn't mean to say that you're a pushover, and you and I have had experience of counsel or criminal advocates behaving pretty poorly and behaving in such a way as to offend against laws. And I've had a case to report a barrister to his head of chambers because of the way he behaved. I might have reported him to the bar council for what he did, but I chose to take a softer course. But all of the decent adjectives, they're the things that make a good judge. And of course, they come down to humanity at the end of it. But how do you want to be remembered? I mean, it may not be the most important thing you'll ever see, but it is nice, isn't it, to be remembered as a judge who's kind, rather than one about whom one would hear swear words.
Mm-hmm. I see. And how does a judge get removed in Great Britain? We had a little bit of a discussion about that. If a judge, in that rare instance where a judge does something that is so serious as to require removal, how's that done in Great Britain?
With difficulty and in rarity as well. I mean, effectively, it's done through the Lord Chancellor. A complaint can be made if his standard of behaviour sounds to be so lamentable. But of course, there are the different ways that will be attached along the way. If he puts in for any promotion in one way or another, that won't be his for having, because nobody does like a bully. But when one hears unacceptable language and unacceptable behaviour, then it can be done. But it's rare, Bill. It's as close as a tenure for life as I think teachers get in certain things.
In Florida, for example, we have a Judicial Qualifications Commission that works for the state Supreme Court. If a judge violates the canon of the canons of judicial ethics, they can get reported. They will do an investigation. I will tell you that from that in Florida, there are several hundred judges. They get several hundred complaints every year. They find probable cause on maybe 3 to 5 per year. They then go through a formal investigation where the judge being investigated has certain due process rights, but ultimately the Florida Supreme Court gets to decide whether someone is going to continue to be a judge. And if they are, sometimes they have an intermediate level of reprimand. So my observation is that the judges in Florida are kept under pretty close surveillance by the Supreme Court, and fortunately we don't have too many episodes that make the international news. But that's
when you say a given due process, does that include a hearing and a right to representation?
Yes. It's actually a trial, and the jury is made up of judges, and really. And it's of record, and the judges are the respondent is permitted to make submissions and argument and so on and so forth, so that at the end of the day, it's a pretty thorough process. There's not much that's left to someone's personal opinion. So yeah, there is that in the state of Florida, and I think that it's fair to say that that's pretty much the standard throughout the various states. The federal government has a slightly different procedure where a federal judge can actually be impeached by Congress, but at the state level, they have all the states have something that's comparable to what Florida has. So I think it's a pretty good system.
Well, Bill, can I just say that I've actually learned a question I've long asked myself, and many people have. So now we know that the answer to the question, who judges the judges, is the judges.
Yes. Yes. Well, we also have judges in Florida are elected. They can be appointed, but they're appointed to terms at the trial court level, county and circuit. They have 6-year terms, and the appellate courts and the Supreme Court are subject to review, a confirmatory vote as to whether or not they should be retained. And it's never happened in Florida, but for instance, at the appellate court and the Supreme Court, if a judge does not get 50% approval from the voters in that election period, then they are not allowed to continue as a judge. In the level of elected judges, county and circuit judges.
And do they those that are subject to election, do they canvass the vote?
They canvass the votes. The judges in Florida, and it's the same way in many other states, they stand for election like other elected officials. The difference in Florida is that it's nonpartisan. And so, whereas in other states, it's a partisan election. And there's a primary vote, which if there are only 2 people in a race, the winner of the primary is deemed the winner of the final in it's usually August and then November. And but every 6 years, the judges have to come back before the voters to seek their approval. And if they've done well enough, they don't have an opponent. But it's always a possibility that a judge in Florida could have an electoral opponent. And so that's what keeps Florida judges grounded, and as opposed to lifetime appointment as they have in other states. In other states, it's lifetime till retirement, but in Florida, it's elected.
Now, I don't mean to moderate the moderator, but what do you think of the system of being partially, a number of them being elected?
Well, I think it's one of the criticisms that's voiced about elected judges is that they become vulnerable to their campaign donors. But that's by and large a myth for a couple of reasons. One is there are campaign donation limits, and election campaigns are expensive. And most people who run for judge, I would say, if not most, certainly a large number self-finance their elections. And part of becoming a judge is to be independent. And I don't know of any instance in Florida's history where a judge has been in the pocket of anyone based on campaign contributions. I mean, a lot of the campaign contributions, if you look at the published reports, which are public, are very small contributions. Sometimes $5, $100. There's not that much. So I think that my bias is that being elected reinforces the notion that a judge is a servant and not a ruler, and minimizes the influence of special interests, politically powerful groups. And again, judges who are appointed are, that I've dealt with, are just as honest as anyone else. But certainly, if you have been through an election campaign where over 100,000 people have voted for you, you tend to think that your duty is to the people you serve. So
let me come back actually, because having said that what we call judgeitis, bullying, is a disease but not a pandemic. Just to show a fully rounded view. You very rarely, I don't know of any instances where judges have been subject to bribery, or corrupt in England and Wales. I may be wrong, but I don't know.
Yeah, it's extremely rare, and one of the reasons is that everything that a judge does in state court is of record. It's in the public. There's very little opportunity to do anything that's thoroughly dishonest. One thing as a public official, if it's hard, it'd be hard to keep a secret if you're doing something you shouldn't do, and there's always somebody looking to find out if you're doing something you shouldn't be doing. So it's another incentive. But there have been cases of both appointed and elected judges that have gotten in trouble for malfeasance in office. That is not unknown, but generally it's a pretty good system, and that's my view of that. And I understand that in Great Britain, it's a appointment for life or until you retire. And let me put the shoe on the other foot. How does that work for keeping judges grounded on serving the community?
Yeah, I as I said, in a way, there's the views that I expressed have been ambivalent because they or have contradictory. On the one hand, I'm saying that they are less sensitive than they might be to the qualities of the advocates who come before them, and they should be more in relation to them. But on the other hand, and it's not just because they don't want to get caught, and it's not just because they're being watched. I generally believe that what brought them into the profession is what keeps them on the straight and narrow. I'm trying to think. Yeah, I was asked as to why it was that I became a barrister and later a judge. And for some reason, I spent time thinking about it. And I came from a family of doctors, and so I used the flip expression that I couldn't stand the sight of blood. But the rock bottom answer, which will apply to you as well as to me, is that we have an interest in fair play, peace, morality, and justice. And it's that really means that we stay on the straight and narrow, not because of a lack of opportunity or a fear of getting caught. That's what I like.
Well, I think American judges are the same way. They're motivated by a love for the law and a love for justice. There are a few of us that have been places where there were no functioning courts and no law other than the weapons that you had at your disposal, and certainly don't ever want to see our society turn into anything like that. But most of the judges that I've dealt with have been highly motivated from the get-go to do the right thing. So I think that there's a lot in common between American and British judges on that score. And to that, I would add that I think people are the same everywhere in every country, and other countries I've looked at, it's the same. It's the same. So going on to some other questions that we've had here. Is there anything like a plea agreement in British courts and in the United Kingdom? Are there, like in American courts, it's possible that the defense and prosecution will come to an agreement, bring it to the court for the court's approval, and the case is resolved that way. Is there anything comparable to that in the United Kingdom?
Yeah, it used to be, I think, more akin to the American system than it is now. So there were circumstances where you could go and see a judge and ask him for really some quite definitive view about what sentence he would pass. Nowadays, you can ask what a maximum sentence would be in a particular situation, but it's not more precise than that. But it becomes akin to being a plea bargain when it goes on between the two parties. One party offers the other a plea to a lesser count, and the other party says, yeah, okay, he agrees that will happen. But what you can't do, by and large, other than the circumstances that I referred to, bring the tribunal, bring the judge into the sentencing process in advance, other than by asking for that direction, toward a good year direction. If I can, Bill, if we've got time, I will give a nice account of a tale where I represented somebody. I intimated on a previous occasion that I'd done a hearing in British Indian Ocean Territory, which is, I think that's where it's an island owned by the British and leased to the American forces. And I ended up representing an American Marine who was not a military, but was a merchant Marine in the sense of the United Seaman Service. And he was prosecuted for assault of someone on the island of Diego Garcia. And in that case, somebody came out to try the case. And I went to see him over a cocktail. And we discussed what the appropriate sentence would be, and I explained that it would be a fine. And he was only on the island by a murderer. And the American I was representing was not a murderer. So this was small beer. And that's what he should do. He should find him, making sure that he find him sufficiently small so that the remains could be paid for my decent return to their home back to England. But that was my life on a paradise island.
Mm-hmm.
Probably the best 6 weeks of my career.
Mm-hmm. Sounds like it was quite an adventure. In American courts, traditionally, the only plea that a judge cannot refuse, no contest plea, is what's called an open plea. Judges traditionally in American courts can decide whether to accept a guilty plea or what we call a no contest plea. They can refuse to take no contest pleas except where the defendant pleads open. That is, no preconditions as to sentence. Is there anything like that in the courts in Great Britain?
Absolutely not. While you were telling me that, but I was thinking, gosh, I just wonder how long it takes to become a counsel who is able to do what is paid one way or another to do, which is to give advice to everybody to what's going to happen. And you have to be pretty in touch, in tune with what goes on with the process in order to do that. And frankly, you were just talking Greek to me. I mean, I'm always happy to learn a foreign language, but that was just very different to our experiences over here. Things like no contest. I don't even know what that means.
That would occur when, for instance, there's no agreement between the prosecution and the defense. They have intractable differences and they pitch it to the judge to work it out. I've never had a situation like that. I don't know of anyone who has, but the law does allow that. In other words, a judge can simply refuse to accept a plea, no contest, insist on a plea of guilty. Judge can also refuse to, in America, a judge can refuse to accept the conditions of the agreement between the parties, and cannot substitute conditions without the consent of both parties. Is there anything that approaches that in the courts in Great Britain?
That begins to sound like some words somewhere in the back of my mind I have heard. Yeah, so when, for instance, a really serious assault is charged as grievous bodily harm, and the parties between them agree that they will accept the defendant's contention that he only was responsible for active bodily harm, then that will be a plea put before the court. And the judge can turn and say, well, actually, you made this, but I don't. And I think a jury wouldn't disagree with popular one way or another. And that's the issue that must be determined. But I think I don't know about where you are, but this is a sausage machine. It's a system that has to work and work efficiently. And where judges start as a matter of frequent interrupting and saying, well, this is my view, rather than the parties, they know the case better than we do. And if they know, for instance, the Crown knows the difficulties it has in proving its case, and they'll take that into account, and the defendant knows the quality of the individual he's representing, and they'll take that into account. So there are good reasons why it may be that they will come up with this, but the judge isn't privy to it. So I suspect you agree that it should be the exception rather than the rule. If you start saying, well, actually, that may be exception to you. As my wife says, Nigel, it's not always about you. Not everything.
Right. And most judges in America recognize that the attorneys know much more about the case than the judge does on a given basis. Let's see here. We have a bunch of questions from those folks. All those folks that were on the Zoom call missed you. They felt deprived. So,
well, I missed them, Bill.
They let's see here. Let's see. Now, you've mentioned about lawyers traveling to court. How spread out are the barristers in England? Are they mostly around London, or do they have barristers in other cities?
No, they do. They have barristers in all the main cities. But very often, the individual party will choose to be represented by somebody not from their own city, but from another city. The frequent position is that a defendant who's being tried in Manchester would say, fine, but I want to be represented by somebody because I believe that they are, in inverted commas, better. I don't want to be represented by somebody from London. Easily somebody from London. I know a good brief in Manchester. I'm going to be represented by them. And you will be paid actually to travel, but often you will be paid the local rate rather than the national rate, and that means that you're putting your hand into your own pocket. But then if the fee for the case is good enough, then it's worth doing. So I would generally spend, I suspect, about 4 months a year. It's quite a long time in a different city or county to London. And so I would often go to Manchester or to Wales. Sometimes you'd be treated as a long lost brother, and sometimes you'd be treated as the enemy within. Somebody come onto our patch to steal our work. So I think I mentioned last time that actually it's quite useful to be able to move the case rather than counsel if there's a case of local notoriety, which you could say would be better off in some other place to be tried. In my career, I was my career path although I became a judge very, very late. I was a recorder, a fee-paid part-time judge for the best part of 20 years, and I was doing that work at the Old Bailey.
And you were called a recorder, is that?
Yeah, a recorder. Yeah.
So most Americans have no idea. They think a recorder is a woodwind instrument.
Yeah, but you're right. So so you apply to become a part-time judge. It leaves open more readily the fact that you may transfer to the bench later on. But it's nice to do things and see it from a different perspective. And that's an interesting point in itself, the perspective of a judge. As a bit of a naughty boy barrister, when I was sitting either a recorder or then a judge, I used to be able to see life in the arena as it's in a golfing game. Oh my goodness, I must have driven everybody absolutely mad. because you can hear every word of this that's being said by the parties and see everything that's going on. But I did enjoy my time as a reporter. Now, what were we talking about?
Well, I was going to move on to something else about the right to remain silent in America. It's enshrined in our Constitution, and I understand that in Great Britain, an inference of guilt can be drawn by someone, a defendant, remaining silent. How does that work?
Well, it works almost as you described it, which is that at the end of the prosecution's case, the moment comes for a defendant to give evidence. This is the right to remain silent in court. Either he chooses to give evidence because he'll be warned that this is the moment he's giving evidence. If you do, there'll be judge subject to cross-examination. If you don't, the jury will be capable of inferring guilt from your silence. Now, that doesn't mean to say that they will infer guilt, but it gives them that right. And so it's a decision that's quite difficult to actually glean and to draw on. And I've, forgive me mentioning nothing like the truth yet again, but I do describe in the book some of the cases in America, some of the better known cases, and where silence was exercised in circumstances where I was surprised that they would be, and believed that the defendant had to come forward in those cases just to be heard saying not guilty, explaining why they're not guilty. The other instance which surprised me, perhaps when I looked at this situation, was in cases where the defendant themselves would remain silent, but they would call evidence from others. And I was always, as a tactic, very, very much against that, on the basis that if you can't come forward and give your own account because you're worried for something, why on earth would you call somebody else to come forward on your behalf? And why would you allow your fate to rest in the hands of another? And an American case I remember, particularly a high celebrity, was Mike Tyson, when he was charged with rape, and he chose not to give evidence. But he called somebody to speak about the events of that day. Now, somebody who is brave enough to enter the ring with the other big heavyweights at the time, to not come forward on his own behalf, I found that amazing. And I think the jury weren't particularly enamored with it either. I always thought that there are people who have to give evidence. Police officers when charged, doctors, priests. If they're not giving evidence, then the inference is bound to be recorded against them. I think the inference, the right to remain silent in the police station when being questioned, that's a different kettle of fish. And those that say, I was advised by my solicitor to remain silent, you can understand it, it's proper. And I don't think the jury takes against those that do exercise that.
Very interesting. Now, I understand that you have some admiration for Abraham Lincoln, famous American lawyer. And
I say, if I was able to swivel around and show you my bust of Abraham Lincoln, but well, frankly, then I would have been able to join in the Zoom on the last occasion. But as I could do neither, I know that I've shown it to you, so you know that I have a piece of stuff. And I was thinking actually about it in the last few minutes, knowing we were going to mention. And I think it's quite interesting, first of all, because when you ask about the quality of decency that you would expect from a judge, then there are qualities, in my view, that are encapsulated by Abraham Lincoln. When we came to Washington, we thoroughly enjoyed following the DC. We thoroughly enjoyed following the Lincoln trail. But I've always been a strong admirer of it. But the other reason that it's quite important is this, is that I know you've spoken about, and we both agree that well-being and mental kindness is very important in our profession, amongst ourselves and amongst lawyers. Well, the wonderful bust that I showed you of Lincoln was actually created as a piece of sculpture by a close friend of mine who I used to share rooms with in an art school in a school of art where I would go every week. And I've been doing that for 4 or 5 years. And that is because mental health, well-being, and health is vitally important. And so that's one of the ways that I turn up, and I'm lucky to have it, to be able to think outside of my job.
So, how much of a problem is the lack of wellness in courts and in Great Britain, and how much of that is the responsibility of the presiding judges?
Yeah, well, it's not. It's the lack of recognition for it that's important. I've spoken very open about two aspects of it. One was that within my career, there were 4 people who I know who took their own lives in different positions. That was the first of it. Secondly, the maintenance of well-being, overseeing of it within the profession of advocate has come much to the fore in the last few years. And there are mechanisms that are going to be able to take it into account. Say, for instance, that the chambers are going to be able to set up mentoring systems, have somebody overseeing wellness. The same can apply within the offices of solicitors. I think the difficulty will be, well, there are 2 difficulties. The first, of course, is I don't know whether you have a stiff American upper lip, but of course we have stiff British upper lip. And to have our stiff upper lip, rather than to actually bring to people's attention the fact that we are suffering from our own difficulties in well-being, is one of the problems. And the other problem is courts. I don't know about your court. They're just not set up really for there to be the proper oversight as to what is going on as far as well-being. I do a lot of things, and I do most of them badly, but I do them. And one of the things I did was to sail. And when I was sailing, there is as those that sail will know, there's the guidebook, the basic guidebook, Reed's Almanac. And in Reed's Almanac, it says, be very careful and listen to if your crew goes silent. If they go silent, they are probably feeling seasick and they're going to be ill. And there's sort of got to be the same antenna, I think, within a court system whereby there is proper concern about the wellness of those that are around. How that is built, I don't know. Where is America on this?
Well, there is a great emphasis on well-being. For one thing, the Florida bar for many years has had a program for lawyers who are having trouble with substance abuse and other sorts of things, where they can anonymously get into the program and get paired up with a mentor. I think certainly the judges that I deal with are very understanding of those kinds of problems. There are also occasionally a judge has an issue like that. The Judicial Qualifications Commission has programs that are available to them to steer a judge in the right direction. I think we're at a point where I would say across the board in Florida, the other states, and in the federal system, that certainly the judiciary is very sensitive to these kinds of issues, because we live in a very high stress era, and issues like substance abuse and mental health are just prevalent throughout the society. So I think that my experience has been that there is a good view of it. It's not perfect. We have what we call problem-solving courts in America. to deal with people with substance abuse problems and mental health problems, and occasionally there are lawyers who end up because of transgressions ending up being in those courts.
Right. But do you think you're adequately? Are you providing adequately for those within the system to provide for lawyers?
I don't know what additional resources that we would have for that. And like you and like others, I have known attorneys who have ended their own lives for various problems, and each one of them is a tremendous loss and certainly a failure of the system to catch it. But I know that there's a lot of, and I see it increasing in our state, a lot of concern about that. I don't know about the resources. I haven't had a situation where I've had to refer somebody to a program yet. So it's probably unknown and unknowable at this point, but it is recognized to be a problem throughout our system and throughout the other states' systems and in the federal government. We're a long way from the days when lawyers were expected to be tough guys,
right,
and judges were expected to keep their problems to themselves, and so on and so forth. So let me ask you this: what do you think Americans can learn from the British legal system? When we had our revolution, we took the British legal system. We thought we improved it, along with the language. We dropped the extra U's and stuff like that. And thanks to Noah Webster, is there something that you think we could take a lesson from in terms of how the British legal system operates?
Well, I'm slow to say this again. You're aware that I came to Gainesville as a guest of the Florida Advocate. I was a Queen's Counsel, not a judge. So I was invited to join the panel of judges in Gainesville, and I listened to mock trials that went on, and there were two visiting British advocates, young British lawyers, and I have to say that they showed all of what they have learned, both academically and their time in pupillage and training before they went out into the court, all unattended on their own. And also then I listened to the young Americans. And I just felt that the Brits knew where they wanted to get to without, funny enough, the flamboyance that I suspect Americans would say was taught or is taught in the British system, and can be seen just because we wear flamboyant outfits doesn't mean to say that we have a flamboyant ourselves. And there's more than one way to catch a monkey, as they say. And so I found that the youngsters in Gainesville from America were very intent on showing how involved they were and behaving very dramatically, reproducing the noise of gunfire, etc. And at one stage, one of the young American advocates said, and it's right, isn't it, that you then heard the gunfire bang, bang, and there were 4 bangs. And I had to say, can I just ask, as you are defending this man, how does over-dramatize the terrifying effect of what he is alleged to have done really help him? So I think the pupillage and the training system in Britain is good, and it's something that can be learned from. Maybe it is mimicked in the United States. I'm not sure. I think our sentencing, we touched on this on the few minutes that I could be heard last time, the sentencing to people to 160 years imprisonment All that does for me is it reminds me of the old joke about when somebody was sentenced to 60 years. He said, well, I'm 60, so I'll die in prison. And the judge said, well, just do as much as you can. And so apart from that, I can see no point in that.
That might be a legacy from the days when in England they would draw a quarter and then hang someone.
You think just in case they might be still alive?
I don't think it's entirely an American invention, but
okay, fine. We'll share the blame.
But I will tell you that those kind of sentences are very unusual, and they're usually done by lower level judges, and they are often reversed. There is a very strong principle of proportionality in American sentencing. That's one reason why we have sentencing schemes that we have, and it's unusual. I think the average judge understands that people live only so long, and a sentence that exceeds the natural life of the defendant is in effect a life sentence. I can tell you that one of the things that's changed in the law in Florida and nationally regarding juvenile sentencing is that for example, the law used to be that for juveniles convicted of murder as adults, they could be sentenced to life without parole. That has been struck down by the United States Supreme Court and by various state courts. And now the juveniles who are sentenced as adults are entitled to a review at different points in their sentence. It is still possible to get a life sentence without parole, but there's a whole lot of factors that have to go into it. The emotional type sentencing that you referred to is unusual. It's often done by part-time judges at the lower level, not recorders, but judges who are at the county or municipal level. And they and you know, there's a big splash in the media, and in fact, I do keep track of some of those sentences to share with colleagues, but as a way of saying, don't do this. You don't want to be in the paper with this kind of publicity. But those are unusual, and I think that the culture in America is getting away from institutionalization as the ultimate solution, and if for no other reason than it's impossible to build enough prisons to build out of the problem. So
we've slightly gone the other way in as much as we now have more regular sentences where life means life. I was involved, if anybody can be bothered OAKES, where the degree of horror that he inflicted upon the house that he entered was such that he was one of the first to do the sentence of life means life imposed on him. It was tested in the Court of Appeal to the extent of its compliance with European law and human rights, as to whether or not it was in line with the human rights to life, etc. And it was said it was properly believed. But the problems that we have in sentencing are difficult in that they're different. It's the ones where somebody ends up with someone is sentenced to 4 years for burglary, and you know that he is only going to sentence the third 2 years of whatever sentence is imposed, and then there's the credit for his pleading guilty, which is a reduction of a third, and in the end, it's hardly worth the journey to go to prison before he's released again. So, in your system, when somebody is sentenced, what proportion of the sentence do they do?
Well, the depends on whether or not there's a mandatory minimum sentence. Typically in our in our system, the state system, there is not a special allowance for acceptance of responsibility like there is in the federal system. And so the ultimate, in imposing an ultimate sentence, it may be mitigated by various factors. The judges can do what we call downward departures. And whatever the result is, the defendant is entitled to credit for time served. Whatever incarceratory credit they've got is deducted from their sentence. Plus, they're allowed what's called good and gain time. So it's possible that someone who's been in the county jail for a year gets sentenced to a sentence of 24 months Department of Corrections. They may be out in a matter of a few months because of the credit that they've accumulated and the good and gain time. But then if there's a minimum mandatory in some provisions of the law, a defendant is not entitled to good or gain time. And it depends on how that statute's actually written. So it's possible that a 3-year minimum mandatory means 3 years without credit. Then on top of that, as far as older or ill inmates are concerned, in Florida, the Department of Corrections has a lot of discretion in terms of compassionately reducing someone's sentence. It's, for instance, if you have an inmate who is dying of cancer, the Department of Corrections is very sensitive to that. They know how traumatic it can be for someone for them and for their family to die in prison. And so they will often compassionately release them to a hospice. They're actually, doesn't get a lot of publicity, but human dignity is an issue in a lot of our sentencing provisions that we have here in Florida. And I'm sure that that's shared by other states and in the federal government. So what do you think that the people in Great Britain can learn from American legal systems? Is there anything that we have to offer that might be worth mimicking, or at least taking out for a test drive?
Most of my experience of the American justice system comes from the movies, like My Cousin Vinny. I don't know whether or not I don't know whether you're familiar with the film.
Say that again. I'm sorry.
Are you familiar with the movie My Cousin Vinny?
Oh, well, I've never had that experience in my courtroom, and I don't think it would end very well for the attorney who acted that way. It's a funny movie, and it's every time we have discussions of trial tactics and stuff, that movie does come out and come up, but no, there's nothing, not much that's realistic. And I'll tell you a little backstory to that movie. When they were researching that movie, the folks who were looking for the right courtroom, the right atmosphere, so on and so forth, went to a small courthouse where they had a prosecutor and a defense attorney and a judge, and they were trying a murder case. And and they had a lunch break. So during the lunch break, the counsel tables were pulled together. The judge and the two counsels sat down, the three of them, and they had lunch. Didn't talk about the case. And then when lunch was over, the tables were pulled apart. The judge went on the bench. The attorneys went to their separate counsel tables, and they continued to advocate for their cause. And the people who put the movie together were very impressed by the civility that reigned in that little tiny courthouse in the middle of nowhere that they visited. And I think that's it's masked by the kind of dramatizations that we get in the media. This is one reason why I say most of what people in Great Britain know about the American legal system simply isn't true, and why we're doing Zoom across the Atlantic. So
let me clear this up with you, if I can moderate the moderator for one more time. When you see in the movie that the advocate turns to the judge and, much to the surprise of his client, withdraws his plea of not guilty and enters a plea of guilty, is there any truth in that?
No. In order for a plea to be entered, let's imagine during trial, and this has happened to me as a prosecutor and as a judge, the defendant always has a right to enter a plea to the charge, and but before the plea can be offered, the attorney has to consult with their client. Their client has to give full, voluntary, informed agreement to it. If it was done, say, during a trial, and there was this sudden announcement, that would result in a mistrial if it was not consented to by the defendant, and it would cause problems with the regulators for the attorney to do something like that, which is obviously contrary to the client's best interest. What has happened in these cases is that the attorney has approached the bench, said in the presence of the prosecution, "We've been talking, we've come to an agreement. Would Your Honor accept a plea?" Yes, the jury is sent out. There's a colloquy with the defendant, and it takes, in my case, the average colloquy takes at least 15 minutes. That covers whether or not it's, and it would cover the disposition of the case as well. So there's no, so that kind of stuff is not accurate. If that's helpful to you.
And what about any of the advocacy being done from the seated position?
Being done from where?
The seated position, without standing up.
Some it doesn't happen in my division at all ever, and some judges do tolerate that, but I don't think that that's the norm. I think in American courts, much like in British courts, that the advocate is expected to be standing and addressing the judge. I'll have to send you a copy of some of the rules we have in my division, so you can see how similar it is to.
I think from our discussion, we would be looking for airtime to be filled by talking about the things that we can learn from the other system, which is lacking in our own. I think there's much more that joins us than divides.
Well, I think so too, and I think that and one of the things that has provided an impetus for these kind of discussions is that there's actually much more that we have in common. There is much more we can learn from each other, and I think that it's worthwhile. There are some things that we do that I'm sure would never work in British courts, and there's some things in British courts that never work in American courts. But civility, professionalism, preparation, things like that. I mean, if we had more time, we'd get into things like the difference between discovery and a bundle and that sort of thing. And I think that by learning from each other, we develop greater flexibility in terms of serving the law. So that's kind of where I'm at for that. Do you have anything else that you want to talk about? I've taken a heck of a lot of your time, and I know it's late over there.
No, it's been a real joy to speak to Florida. It seems to be a state that I'm becoming more and more drawn to. I'm always happy to visit for any reason. It always strikes me as to how it is that Florida finds itself at the center of every presidential election. As they suggest, you must wait for the spotlight to shine on you.
Florida is a very special place. I'm very fortunate to live here. My wife gets credit for that. When I was at the end of my military career, Colette said, "We're moving to Florida and you're retiring from the Army." It's been a very good choice. And certainly I wish you and all the others from Great Britain who participated in this program would be able to come to Florida and enjoy the warmth and sunshine and freedom that we perhaps take for granted here. But it is a great state. And contrary to what some people think of Florida, it's actually very, very advanced in its approach to things. And I think the people are very open-minded. And certainly I can tell you that my colleagues here in Florida are very excited to view the results of this edition of Zoom Across the Atlantic. So thanks a lot for participating, and we'll be in touch. Take care, my friend. Have a good evening.
And you, Bill. Yeah.